Hello, everyone. Welcome to Court with Krissy. Here are 4 court shorts you probably didn't catch. Well, maybe the last one you watched with Law Daddy, but believe me, it's worth watching again. However, my favorite, I'm sharing first. Dynamite. I did some detective work, and it turns out he used to be a boxer. Perhaps he's taken some blows to the head. He is the sweetest guy, and I think you'll like it. Court with Krissy is now in session.
And now we're here with Ypsilanti Township versus Derek Todd McGuire, 23T000660M.
Again, Paul Barnett on behalf of the township.
Is there an attorney here for Mr.?
Yes, Your Honor. I'm sorry about that. This is Matthew Mansour, Assistant Public Defender on behalf of Mr. McGuire. Mr. McGuire, can you please state your name?
Yeah, my name is Derek McGuire, Derek Todd McGuire.
Good morning, Mr. McGuire.
How you doing, young lady?
I'm doing just fine, thank you.
Okay.
This is a day and time.
Okay, I like your hairstyle.
This is a day set for the settlement conference. Can the attorneys have an update?
Your Honor, at this time, the township is not in a position to proceed to trial.
Okay.
Defense would move to dismiss, please.
One more time. State that one more time.
The defendants, your attorney, Mr. McGuire, the defendant's motion to dismiss the case is granted without prejudice.
He is or he was granted.
Mr. Mansour, is your client being held on anything else?
Your Honor, I'm double checking right now. It looks like he's being held on a $100 bond that's coming up on December 11th.
Okay. This case is closed out, and so I'll leave you to your work on the other case.
Thanks, Your Honor.
All the bond conditions are released.
Thank you. We're all set, Mr. McGuire. Your case is closed here.
My case is closed?
Your case is closed.
Okay. Cool.
You can let the deputies know your hearing is over on this case, and your attorney will be in touch with you on your other case.
Okay. You know what? Dynamite! Dynamite!
Take care, Mr. McGuire.
Dynamite McGuire is here. All right?
People of the State of Michigan versus Alante Jaquan Lindsay, case number 25FB1033FY and 25FB1152F.
Jetty Reyna. Miss Reyna, are you feeling okay today?
Not really.
Do we need TPC to come by and see you?
Yeah.
Would you talk to him if I sent him around?
Yes, ma'am.
Do you ever have a TPC caseworker?
I got established for services, but I don't know.
Okay. Now you have an address, right? Okay. What made you be over on Washington Street?
Well, me and my boyfriend got into it, and the cops took me over there, and I guess I got drunk. Yeah.
Okay. So if you get out today, do you have a place to go?
Yeah. I was kind of hoping maybe I could get into the pavilion after I get out of here.
Well, if you want to be considered for the pavilion, then you might want to stay there instead of get out, because it's hard for them to find you if you're out and about everywhere all over town. So we'll talk about what you want to do. To the charge of public intoxication from this morning, fine range is $1 to $500. Court costs are $81. Do you want to plead not guilty because you want to?
I'm guilty.
Okay, on your guilty plea, finding court costs is $484. I'm going to give you $150 jail credit.
Okay.
Now, do you want to sit out the balance so TPC has time to come by and see if they can make a place for you at the pavilion? Because otherwise you're going to get processed out today by about 2 or 3.
That's fine.
But if you voluntary remand, TPC has time to come and see you there at the jail.
What's voluntary remand?
I'm sorry,
What's voluntary remand?
what is voluntary remand? That means you say, I don't want to appear, I don't want to pay, I don't want to do community service, I just want to sit out the rest of the ticket in the jail.
Well, can I just stay here until they get around to seeing me?
Yeah, that's called a voluntary remand. And then that way they have time to come give you a full assessment and see if you qualify to go to the pavilion.
So how long would I be in here?
Let's see. Okay, so 484 less 150, we're talking about 344. You'd be there, well, unless they need to take, if they need to take you to the pavilion, they'll let me know and I'll release my hold on you. So if they don't come by and they don't think you qualify for the pavilion, you'd be out, today's Wednesday, Thursday, Friday, you'd be out sometime Saturday morning. So do you want a voluntary remand so TPC has time to come by and evaluate you? But if you need to go to the pavilion, I'll release my hold on you to let them take you there.
Yeah,
You want to do that?
yeah.
So I'll tell you what I'll do. You sign that voluntary remand form in the back. And
Okay.
if you're still there, and they haven't asked to release you, I will see you again on Friday morning.
Okay.
I call it a receipt on 10/31. And then I'll send an order for TPC to come and check on you. Okay, hopefully today.
Okay, thank you so much.
Okay, thank you. Bye-bye.
Virtue versus Andrew Ennis 25-02467. SM appearance, please.
Good afternoon, Your Honor. Timothy Young appearing on behalf of the defendant Andrew Ennis.
Okay, this is a matter that's before the court for a bond violation. It says here in a complaint that it's upon reasonable belief that on October 28th at 0100 hours, the defendant, Andrew Ennis, was driving a Ford Mustang while the protected party in the underlying matter was the passenger. There is a no contact order, it states here, indicating that the defendant is not to have contact or be in the presence of the protected party, Nevaeh Shisia, or Shisia, I'm not sure how you pronounce that. And so that's a bond violation, which is a contempt of court order. For your information, Mr. Ennis, you can be sentenced if found guilty of a violation to a maximum penalty of 93 days in jail or and or up to $7,500 in fines. Do you understand that?
I do.
Okay, looks like the defendant was previously arraigned by Magistrate Milmore on a domestic violence on August 26th. And bond was set at 300 personal recognizance. He was advised that he was not to have contact directly or indirectly or via third party with Miss Shisia, and that he was supposed to provide a valid address within 24 hours of his release as to where he was going to be staying. There was a bond recommendation at the time that bond was entered. Let's see here. For a money bond with conditional release. And it looks like the magistrate deviated from that. Counsel, did you want to address the court before I address his new bond?
No, Your Honor, I would just indicate that he is currently disputing, obviously, the domestic violence charge that is scheduled for a final pretrial conference in another couple of weeks. It's our anticipated hope that that would be resolved. Clearly, there is no excuse for violating the condition of his bond. I'm not here to in any way try to justify that. He is employed. He does not want to lose his job. He has been a lifelong resident of this community. He does have a different address that he is able to provide this court if that is not already available to it. And so we would ask that the bond be continued as a PR. If it needs to be a 10%, he's willing to do that as well, just given the fact that he has clearly not understood the parameters of what he needs to be doing to satisfy the conditions of bond.
Does your client have an issue with understanding?
Well, Your Honor, I think that that's not so much understanding what he's supposed to do as much as it's there being a dispute that there was ever any domestic violence that occurred between the parties. Again, not relevant to the issue. I've made it clear to him what he has to do. He cannot be around her, can't be with her, can't talk to her, have any contact with her. And so my suspicion is that given the time between now and when this matter is resolved, they will not have any further problem abiding by the conditions of a bond that would require no contact.
I find it unlikely because if you have a blatant disregard for the bond already and you get pulled over and have the actual person you're not supposed to be in contact with in the car with you, I don't see any reason why his bond should be continued. I also don't believe he has an issue with comprehension. Whether or not he maintains his innocence has nothing to do with a valid court order. And the court order for you, Mr. Ennis, was that you were not to have contact directly or indirectly with the alleged victim. And I recognize that you are at this point still maintaining your innocence, as you have the right to do. But there are factors that were to be considered when setting your bond. And some of those risk factors include some threats that you allegedly made to even harming of animals. It said that the defendant, of course, was in an intimate relationship with the protected party, and the crime involves violence towards another person. The people previously requested a money bond. I'm going to grant that request at this time. I'm going to reiterate that you are not to have contact. That means no communication, no phone calls, no text messages, no DMs, no letters, no messages through third parties, driving in each other's cars, no visits at each other's homes, no meetups anywhere. Do you understand that, Mr. Ennis?
I do understand.
And that court order is in place until the time that the matter is resolved. That is ultimately for the protection of the alleged victim, but it's also for your protection, because when you are seen in violation of that, you end up in handcuffs and back in jail and risking losing your job and your livelihood. It also could be perceived that you're engaging in activity that could be coercing the victim to not want to appear in court, which is called witness tampering. And that could lead to other charges. Do you understand that?
I do.
Your bond is now 5,010% with GPS tether. You will not to be within 2,000 feet of wherever the victim is. Did you provide the court with a valid address within 24 hours of your release as you were previously ordered?
I had called to report and I was told that because it was a misdemeanor, I was not required to.
That we didn't ask you to call to report to pretrial services. You were ordered to provide an update to the court about where you were going to be residing within 24 hours of your release. And I don't see that you've done that, which would also be a bond violation. Where are you residing?
I gave that address to the, I forget what they're called, the defendant this morning.
Defense counsel?
Yes.
The public defender who you spoke, that's fine that you gave it to the public defender, but your order from the magistrate back in August was that you were supposed to, within 24 hours of your release, give an address to the court.
I simply had misunderstood. I thought I was supposed to report to pretrial services.
Okay. I just want to make sure that you do not have an issue with understanding, because it's the second time with the second issue that I hear that you misunderstood. Do you have an
So-
issue with comprehension, sir?
No, I'm just curious as to who I would have called.
You just need to call the court, 54A District Court, and if you had questions about that, it looks like you have retained counsel, you could ask him, and he could have simply emailed the court staff with a valid address to update on your behalf. And it looks like you've appeared in court multiple times, but the paperwork, I don't know that it's been updated. Nonetheless, you are not charged with a felony, so you do not need to report to pretrial services. You're being charged with a misdemeanor. You just need to report to all of your court dates. And at this point, you need to be otherwise compliance with your bond conditions, which number one includes no contact with the victim. Do you understand that?
I do understand.
Okay. Again, bond is set at 5,000, 10% with GPS tether. And any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
Thank you. You're all set.
Five 5003 FY3. And you are Caleb Moses Picard, is that correct, sir?
Yes.
All right, this is a case alleging count one, resist and obstruct a police officer, first responder. Count two, harboring felons. And count three, resist and obstruct a police officer, first responder. Now, Mr. Jarboe is here today as the arraignment attorney to assist you through this first hearing with the court. So, Mr. Jarboe, have you had an opportunity to speak with Mr. Picard regarding the charges, the possible sentence, and his Miranda rights?
Yes, so we've reviewed the felony complaint. He's aware of the counts and the potential penalties under Michigan law. Where he's waiving further reading of the felony complaint. He's aware of his rights and will waive further reading of those to the court, to the extent the court allows. He's simply asking that pleas of not guilty be entered on these counts. He is going to be asking the court to screen him for eligibility for assigned counsel.
All right, Mr. Picard, you do have the right to have an attorney to assist you on this case. And since you feel you're unable to afford one, would you please raise your right hand? Do you solemnly swear and affirm the information about to give us the truth, the whole truth, and nothing but the truth?
I do.
All right, I'll be asking you questions for the purposes of the court-appointed attorney request and also for bond setting. Are you renting, buying, living with parents, or paying room and board at that Rushton Road address?
Nothing. I don't pay anything.
You don't pay anything?
No.
Do you own it?
No.
And are you single, married, divorced, or separate?
Divorced.
Do you have any dependent children living with you?
Not living with me, no.
Are you working?
No.
When was the last time you did have a job?
2023.
Do you have a source of income?
Nope.
So you have no money in the bank?
I got $1.98 in the bank.
Okay, keeping your account open.
Nope.
All right, and do you own a vehicle?
Nope.
So you own nothing? Okay.
Hmm.
All right, the court's going to appoint an attorney to assist you through this case. You should be receiving information sometime in the next few days about that. All right, this brings us to bond setting on this case. Mr. Jarboe, did you have anything you'd like to say about bond?
Well, Mr. Picard indicates that there is a hold on him from Charlevoix County for a probation violation for which he would like to have taken care of. He believes it may end up with him serving some additional jail time in Charlevoix. So his request, and he describes it as missing a court date versus simply a payment issue. Having said that, he would ask the court to consider a PR bond in this matter so he could be released to Charlevoix, so that he could go to Charlevoix and get his matter resolved there. I simply indicate I would provide that request to the court.
All right, thank you. Well, given the fact that you had a couple of failed to appears here, one being the FOC case in Grand Traverse County.
Yeah, that one I missed by 2 hours, man. I got the
Oh,
time messed up.
Okay, well,
Like, I called them at 11 o'clock in the afternoon instead of 9 a.m.
and that
Because
was
I had
back,
court for 3 different counties at 3 different times for 3 different weeks, and I messed one up.
okay, well, that was back in July.
Yep.
This is back now October, so you've had plenty of time to take care of that by going
Oh,
there.
yeah, and
take care
I
of it.
called him, and he told me if I
Right.
could come up with fucking
Yeah.
$25,000, he'd release the warrant. So I didn't come up with 25,000, I didn't get the warrant released.
Okay.
But go ahead
I
and smack the
understand,
button. I mean, I
but-
really don't give a fuck.
Okay, let's keep our language a little cleaner, okay, sir?
Yep.
Thank you. All right, given the fact that we do have some failure to appears, there is really no guarantee at this point that if we gave you a PR bond to go back to Emma County, that you'd actually show up in ours. So we are going to be
Considering I'm
giving
looking at
you,
9 months in that county, there's a
Okay.
good chance I'll still be.
well,
in
we're
there.
going to give you a monetary 10% bond, which means you're going to be earning credit for time served. So you'll either be getting credit for time served on our case or their case, because you are in custody, okay?
Mhm.
All right, so we're gonna set this as a $10,000, 10% bond.
So $1,000 will get me moved to Charlevoix?
$1,000 would get you
Cool.
to Charlevoix. Yeah,
Get me out of
we're
here.
not
I'm
done.
with this dumbass
Nope.
shit.
We're not done yet. Mr.
What?
Picard, we're not done yet.
We're done.
No, okay.
We're done. You told me
You're not-
$1,000 to get me out of jail. I'm done
Okay,
talking to you.
sir, you're not gonna have that bond if you don't sit down.
I don't even want the bond.
Okay,
Do you think I can come up with $1,000 if I can come up with
Sir,
$400 to get out on child support?
you're
warrant?
getting credit for time served.
Good
Let's
deal.
finish.
On some charges that are some bullshit.
Okay, sir, would you like a bond or not like a bond?
I would love a bond.
You would love
I'd
a
love a
bond?
PR bond so I can go up there and fucking deal with my shit.
Sir,
You can put
Sir,
a dollar
I'm-
down.
okay,
Yeah.
I'm gonna mute you because I'm gonna go through the conditions
deal.
of this bond, okay? Thank you. Now, standard bond conditions will apply. You'll be able to read about those when you receive the paperwork from the court.
Mhm.
Now, no alcohol, illegal drugs, marijuana, minor mood altering substances are to be in
Yeah.
your possession. Do you take medications?
Nope.
All right. And you are subject to discretion, sir, we're not done. Have a seat. Thank you. You're subject to discretionary testing. You're not to have weapons of any kind, no threatening, intimidating, harassing behavior towards any persons. You are to be respectful of all court staff, law enforcement, care providers. Now, you're not to have any contact with Jennifer Robtoy and to stay 500 yards away from
Love
where
you
you
too,
might
lady.
be
Why am I
during the
not allowed to have
pendency
contact with
of
her?
this bond.
Why am I not allowed to
Your
have contact with
court-appointed
her?
attorney,
No, hold up.
Okay,
Why am I not
sir.
allowed to have contact with her?
sir,
Why
your
is that a condition of
court-appointed
this bond?
attorney,
But fuck this. I'm done. Get me the fuck out of this house.
okay, no bond. I'm sorry. We tried. Okay, no bond on this. We are going to schedule him for a probable cause conference on November 12th at 8 o'clock in the morning. And then we're going to be scheduling the preliminary exam, which is required on November 19th at 11 o'clock in the morning at the courthouse in Antrim County. So, Mr. Jarbo,
Okay,
thank you for trying to assist with this particular client. I'm sure his
No issue.
court-appointed attorney
Well
will
done.
try to work something out for him.
you did a good job. All right, thank you. Have a good rest of your day.
Yeah, you too. Take care.
Bye-bye.
Thanks.